We're barely 20 seconds in and already you can feel the chaos returning like an unwanted sequel. Remember, every time Frank Mo steps into court, jurisdiction becomes his favorite topic, but today the judge has no patience left. Question is, will she finally shut down the sovereign citizen script or will Frank stall this exam until the sun burns out? Let's find out.
Sir, I am not going to let you interrupt me.
Oh, you just interrupt me.
I'm in charge. I get to do shit you don't get to do. It's part of the black.
This is 210736FY. This is State of Michigan versus Frank Michaud. May I have your appearances, please?
Good afternoon, Your Honor. Mohammed on behalf of the people, PH6771.
Would you state your name for the record, sir?
My name is Frank Michaud. I am the beneficiary of the Frank Anthony Michaud estate that you are administrating over, and I appoint you as the trustee for the record of the record show. I am here as a native special appearance, not general. I am here on duress and coercion.
Thank you, Mr. Michaud. Today is the day and time scheduled for the preliminary examination. In this matter, there is count 1, weapons, firearms, possession by felon. Count 2, carrying concealed weapon. Count 3, felony firearm. Are the people prepared to proceed?
We are, Your Honor. We do have a couple of preliminary matters.
Before we do that, Mr. Michaud, are you prepared to proceed?
No, ma'am. I'm actually here to get a better understanding of things first before any proceedings.
What is it that you need to get a better understanding of, sir?
For one, is the jurisdiction that the court is operating upon.
Judge, I'm going to object. The court has made a decision on this motion previously. Both you and Judge Oakley have ruled on this, so I'm going to object.
Mr. Mohammed, hold on one second. Mr. Mohammed, what we will do is let Mr. Michaud make his record.
Yes, ma'am. Okay. Constitution, the 6th Amendment grants me the right to know the nature and the cause of the action. So the jurisdiction that you're operating upon for the record.
The next thing, sir. The next thing. You said you had some preliminary matters, which suggests more than one thing.
Oh, yes, the jurisdiction.
Okay, pause mentally right here. The judge is about to outline 3 serious felony counts plus a habitual offender enhancement. Translation: the stakes are sky high, way beyond crayons. While Frank keeps filing arguments about jurisdiction, the court is focused on the one thing that matters today, whether he had a gun when he legally couldn't. Keep that contrast in mind.
Yes.
What's next?
Is this going to be criminal, civil or criminal? And I also want to, with the basis of the answer, I would like to address some other things as well.
What other things, sir?
It's pertaining to off the answer. So,
Mr. Michaud, I think we had this conversation last week. Correct me if I'm wrong. This is a criminal case. It is alleged that on February 23rd, 2021, at the Detroit Metro Airport, which is located in the city of Romulus, you committed the following: that you did possess and or transport and or purchase a firearm when ineligible to do so because you've been convicted of violation of Controlled Substance Act 333.74012A4, a specified felony, and the requirements for regaining eligibility had not been met. Contrary to MCL 750.224F, count 2, carrying concealed weapon, that you did carry a dangerous weapon, to wit, a pistol, whether concealed or otherwise in a vehicle operated or occupied by said defendant, to wit, a Range Rover. Contrary to MCL 750.224, count 3, felony firearm, that you did carry or have in your possession a firearm, to wit, a pistol, at the time you committed or attempted to commit a felony, to wit, felon in possession of a firearm. Contrary to MCL 750.227B, there is also an habitual offender third offense notice on the file where it's alleged that you were convicted of the offense of violation of Controlled Substance Act on October 24, 2013, and convicted of the offense of attempt carrying of a concealed weapon on April 30th, 2002. That being the case, the court having responded to the charges indicated to you that this is a criminal matter. The court's question back to you, sir, is: are you prepared to proceed with the exam in this matter?
No. You still haven't stated the jurisdiction of the court for the record.
I have identified this court as the 34th District Court to you before, sir, and I will renew that indication to you. Are you prepared to proceed with the exam?
No, because Oakley stated that the jurisdiction of the court was Michigan statutes, and that's not what you're saying today.
Chief Judge Brian Oakley, you had a conversation with him about a month ago. We're having a conversation, well, we're having a hearing today. And sir, we're doing one of three things today. We are proceeding with the exam, you're waiving the exam, or we're adjourning this matter. Your response to my question right now is one of those three things. What are we doing this afternoon?
And you also stated that you addressed me having questions, and I had another question pertaining off your answer, and I wanted to read that.
Mr. Michaud, no, we're not doing this afternoon. Exam, waiver.
Well, at this moment, okay, since I'm under threat, arrest, and coercion, I would like to appoint Mr. Sullivan as trustee for me.
Here it comes, the sovereignty spiral. Notice how Frank treats the word jurisdiction like a magic key that unlocks dismissal. But in reality, courts don't reopen settled questions just because someone repeats them louder. Audience question: would you let a defendant re-argue the same thing every hearing, or would you cut them off like the judge does here? Drop your vote.
Mr. Michaud, you're not under any threat. This is a court. You've appeared this afternoon. This case has been called, and if you're prepared to proceed with Mr. Sullivan sitting to your left, this court will proceed. Is that what you're indicating?
Well, you say I'm not under threat, right? And if I continue to ask a question, I will be held in contempt, which is a threat, right?
I never said contempt, sir.
Well,
What we are is scheduled for a hearing, and what this court does is hearings. And I entertained some of your questions, but it is now 2:15, and the court's. I know, sir, but I'm presuming that there will be some testimony.
Okay, but you were asking me, am I ready to proceed? And you, while you're asking me, you also telling me that we're about to proceed. So you're not actually giving me the right to answer the question. You also making it seem like you're threatening me. So,
Mr. Michaud, I'm interrupting you to tell you that I'm not threatening you,
okay,
but
so
I've answered all that needs to be answered from this court to proceed with either the exam, a waiver.
Okay, all right. But you haven't answered the questions that I have asked. I said I had another question, and you're still not allowing me to ask the question. So do I have the right to ask?
What's your question, Mr. Michaud?
I just want to ask you, as far as, hold on one second. I want to read this for you too.
No, sir. You had a question. What is your question?
Can you help me understand this? Okay, according to 27 CFR 7211, it say all crimes are commercial and must have nature and cause and be prosecuted in the name of the people of the states as a real party in interest, not the people of the state, the corporation, the fiction. This is 20 FCFR, right? So I need you to elaborate on this code for me, please, and thank you.
Mr. Michaud, this court will decline to elaborate or respond to that because this afternoon we are here to determine if the prosecution is able to show that a crime has been committed and that probable cause exists to believe that you are in commission of that crime. That is what we're doing this afternoon.
I understand, but
Okay.
it says that possession of a deadly weapon is a commercial crime. So I need to have a better understanding if this is a commercial crime. You said this is a crime and there is no inter party where I hurt anyone. You haven't gave me the right to face my accuser. And it tells me under this code, 27 CFR 72.11, all crimes are commercial. A deadly weapon is considered a commercial crime. So I understand that commercial is civil, but you telling me this is criminal. So how is it criminal? And it says if there must be an injured party for a corpus delicti, for the record, an injured party, and you haven't presented an injured party for the record. So, I mean, can you elaborate on what jurisdiction you operate under? Is this civil or criminal? Because it doesn't make sense.
You're asking a compound question, so I'm going to try to answer it. Last week and just now, you indicated a right to face your accusers. And you indicated that the court will be presenting something. The court is not presenting anything. The court will take testimony this afternoon and review evidence, documents, videos, whatever it is that either Mr. Mohammed or Mr. Sullivan on your behalf presents to this court. You want the right to face your accusers. I don't know who Mr. Mohammed is calling to give testimony this afternoon. I don't know who, if anyone, Mr. Sullivan is calling to give testimony this afternoon. That being the case, sir, are you prepared to proceed with the exam?
Okay, so the Chief Oakley said that he stated for the record that my accuser was the state of Michigan. And here in this code, it says, the prosecuted in the name of the people of the states, not as the people of the state of Michigan. So what he said is contradiction to this code, and it's 27 Code of Federal Regulations 27 7211. All crimes are commercial. So I don't understand.
You were in front of Judge Oakley for a probable cause conference, which is basically a scheduling. Are we having an exam? Is there a plea or is there a waiver? For some reason, that didn't happen with Judge Oakley. You then had a PCC with Judge Green. Then you were with me for PCC last week. I asked you questions, you wouldn't respond, but I tried to answer your questions. And the people twice demanded an exam. And when you would not answer my questions, I scheduled the exam. Mr. Michaud, your only response right now is yes or no. Are you prepared to proceed with the exam this afternoon?
Well, under threat and threat and duress coercion, I appoint Sullivan as my trustee for the record.
And there are the consequences. 2 prior convictions already on record. That habitual offender enhancement, it's not just a title, it can add years to any sentence if he's found guilty again. So while Frank debates code citations, the prosecution is quietly stacking bricks that could build him a much longer stay behind bars. Question: at what point does strategy become self-inflicted damage?
This court was in receipt of a sealed copy of Mr. Michaud's record, and Mr. Mohammed proffered to the court People versus Perkins. And Mr. Sullivan, the court has had the opportunity to review the opinion, and it does indicate that the defendant bears the burden of producing evidence to establish that his or her right to possess a firearm has been restored. That being the case, the court is accepting the certified record that was tendered by Mr. Mohammed. The court also has had the opportunity to hear the testimony of Officer Stempian. And for purposes of this preliminary examination, we'll find that the people have met their burden. And we'll bind Mr. Michaud over as charged. Mr. Michaud, your next appearance date will be on March the 13th, 2024 at 9 a.m. That will be at the Frank Murphy Hall of Justice. Your previously entered bond with any conditions will continue.
Thank you, Your Honor. We are present in the state of Ohio versus Dennis Welp in case number 25 CR 206. The defendant is in court represented by counsel. We were last here on May 14th where the defendant pled guilty to count 5 and count 6, both being sexual battery felonies of the 3rd degree. At that time, the court referred the defendant for a pre-sentence report and victim impact statement. Those reports have been completed and the state is prepared to proceed with sentencing.
Mr. Watson.
Thank you, Your Honor. May it please the court. I'm going to be brief. This was a heinous crime, Judge. This was horrible in a lot of ways, but most importantly, because this was a minor child who almost assuredly didn't fully understand what was going on with somebody whom was entrusted to love her and to protect her. However, Your Honor, this is not indicative of who Mr. Welp is as a person. Yes, he has a record. Yes, he has been to prison, but it's mainly in the past been for drug offenses, I believe some theft offenses, nothing of this magnitude. On this day, and this is not an excuse, Judge, for his behavior, but on this day, Mr. Welp was drinking a lot, was highly intoxicated, and took advantage of his stepdaughter. Since the day I met him, he is in disbelief that he did this. He has expressed to me his remorse and his sadness and how he hurt her, how he hurt his wife, how he hurt the rest of his family. He knows, Your Honor, that he's going to be spending a lot of time in jail coming up. I know there's discretion with the plea with how much time that equates to. This court has a lot of discretion with that. Earlier in chambers, the state and I presented to the court a joint recommendation for 8 years. I'm going to respectfully ask the court to consider imposing that sentence because I believe Mr. Welk is remorseful. I believe that this is not who he is as a person, and I'm hoping when his time is up and he gets out, which by the way, he's going to be reporting as a sex offender for the rest of his life, so he's going to be under a microscope, he's going to be monitored for the rest of his life, but I'm hoping that he'll be able to piece things together, make amends with at least part of his family. I don't know if he can ever make full amends with everybody or not. And you're going to hear from him in just a minute, Your Honor. But again, I don't think this is who he is as a person. And I'm going to respectfully ask the court to consider adopting the joint record.
Listen closely. The judge has now distilled the entire chaos into 3 options: move forward, waive, or postpone. Frank hears that and still tries to negotiate a 4th option: endless rhetorical loop. It's like ordering off menu at a restaurant that only serves 3 things. Eventually, the chef just stares at you.
Thank you, Your Honor.
All right. You are required to register in person with the sheriff of the county in which you establish a residency within 3 days of coming into that county, or if temporarily domiciled for more than 3 days. You are also required to register in person with the sheriff of the county in which you establish a place of education immediately upon coming into that county. If you establish a place of education in another state but maintain a residence or temporary domicile here, you are also required to register in person with the sheriff or other appropriate official in that other state immediately upon coming into that state. Failure to register, failure to verify residence at the specified times, or failure to provide notice of change in residence address or other required information as described above will result in a criminal prosecution. Mr. Watson, if you would present this to Mr. Welk for his acknowledgement and signature. All right, Mr. Welk, what do you want to tell me before I impose sentence?
First and foremost, I'd like to apologize to the courts for appearing before them today. I'd like to apologize to the victim in this case. I'm not going to use alcohol or drugs as an excuse for anything. However, alcohol was the main factor in this case. But I take full responsibility for my actions because I chose to make the irresponsible decision, consuming too much alcohol than I could handle, causing poor, regretful choices leading to my incarceration. I've read the police reports and feel ashamed, embarrassed, and hurt because that's not the person I am. And I wouldn't be standing here today if I would have just been more responsible. I have 4 younger children that I've let down because of being locked away from them, missing out on watching them grow. Having to deal with that is a heartache alone. The only thing I can do now is work on myself while incarcerated, take advantage of all programs they offer, and become a better man and a better father, and not give up doing so. I have to make this my last time in jail, and I plan to. I'm sincerely remorseful to my victim in this case, letting her down when I was supposed to be a father figure in her life. I beat myself up over this every day. Over this, wishing I could take it all back. I just hope she can grow up in life and leave this in the past, and that it doesn't affect her future. Again, I'm sorry to everyone I caused pain to in this case.
Ms. Alessi?
Thank you, Your Honor. One thing that the defendant said today in court, and even in his pre-sentence report, that stood out to me is that he was supposed to be a loving and caring father. And I couldn't agree more with that. He should have been someone that the victim could trust and rely on for protection and guidance. And instead, he used his role as a parental figure to manipulate her, exploit her, and violate her. And while there is a jointly recommended sentence here, the state believes it's essential to highlight not only what the defendant did pre-indictment, but also what he did after his arrest in this case. While incarcerated, he continued to communicate with the victim while in the Lake County Jail. He attempted to guilt and manipulate her by blaming her for her own suicide attempt at the East Lake Jail. He pressured her to express her feelings to law enforcement about her desire for him to only receive a short sentence. He spoke of wanting to attend counseling together. He emphasized they were a team and told her he loved her, despite being her abuser, despite doing what he did here. And during several of these recorded calls, you can hear the victim crying, further illustrating just the ongoing emotional harm caused by the defendant and his conduct.
Okay, this is the moment sovereign citizen bingo players wait for. The famous all crimes are commercial line. Here's the truth. 27 CFR section 72.11 defines property categories for federal forfeiture, not the nature of crimes. It's about stuff being seized, not why someone is charged. So when Frank uses it here, it's like reading the dictionary definition of banana to argue you're not speeding. Wrong document, wrong context, and the judge knows it.
This behavior demonstrates his continued disregard for the well-being of the victim, his family, and his ongoing efforts to control her and manipulate her. The defendant today in court said he's remorseful, but in the pre-sentence report, he didn't believe he did anything wrong, and he wants to take this to trial. So I'm not sure what this court can believe. He has a lengthy criminal history, including 4 prior prison numbers and 5 felony cases. And all of this, I think, supports the need for a significant term of incarceration, and respectfully ask this court to impose a jointly agreed sentence of 8 years. Thank you.
Thank you. Why did you call her after you were in jail?
Because I was told by the detective I was allowed to.
Okay.
I didn't call her. I called my wife, and she answered the phone.
All right. And what contact did you have with her about retracting her statement or modifying her statement?
It wasn't retracting. It was. We talked about counseling, going to counseling and stuff, because that was something that they was talking about making them do, and something she said she didn't want to do.
Well, trying to, whether directly contacting her or contacting her through your wife, was wholly inappropriate. And it was further evidence of you trying to take advantage of her at that young age, like you did when this happened.
Now she had asked the detective if she could have contact with me when this case was all started.
Ooh.
Then when I went to my preliminary hearing on February 11th, I asked the detective, and he told me the same thing.
All right. Well, you're experienced enough in the system to have the wisdom that you shouldn't have been contacting her. Okay. In talking to her, having about anything having to do with this case. So, you've in your statement, you say you apologize to her, but then in the pre-sentence report, you talk about how you don't believe you did everything you're accused of doing and wanted to take this to trial. What's that all about?
I don't remember exactly what I said, Your Honor, but what I was saying was I don't have recollection of what happened the night of, so I wasn't admitting to, I don't know what happened.
So did you or didn't you do this stuff?
Yes.
And I gotta tell you, it doesn't get much worse than this kind of stuff.
I understand.
And I would note in the record that in 2009 or 2010, you were sentenced to prison on a burglary, released on judicial release, and then returned to prison after a violation of the judicial release. And you were released January 7th of 13. You went back to prison on another case on May 1st of 13 and got out in August. Went to prison on an attempted burglary, trespass in a habitation, breaking and entering, June 23 of 16 through August 5 of 18.